In every civil or criminal case, the court does not decide the matter merely on allegations. The party who makes a claim must prove it with evidence. This legal responsibility is called the burden of proof. The concept of the burden of proof ensures that judgments are based on facts and evidence, not on assumptions or guesses. Meaning of burden of proof. Definition. Burden of proof means the legal obligation or duty of a party to prove the facts that he or she asserts before the court. In simple words, the person who makes a claim must prove that the claim is true. The burden of proof decides which party has to produce evidence first and convince the court about the truth of its case. Simple definition. Burden of proof means the responsibility of proving a fact before the court by producing sufficient evidence. Legal principle. The law follows the famous principle: he who asserts must prove. This means that the person who alleges a fact cannot simply expect the court to believe it. He or she must support it with evidence. Who bears the burden of proof in a suit or proceedings? The burden of proof lies on the person who would fail if no evidence were given by either side. This means, if neither party produces any evidence, the party who would lose the case has the burden of proof. That party must first prove the facts necessary for success. General rule. The burden of proof lies on the plaintiff in a civil suit, because the plaintiff brings the claim. The prosecution in a criminal case, because it alleges that the accused committed the offense. Can the burden of proof shift? Yes. Initially, one party has the burden of proof. Once that party produces sufficient evidence, the burden may shift to the opposite party to rebut or explain the evidence. Types of burden of proof. 1. Legal burden, persuasive burden. This is the obligation to prove the entire case. It generally remains on the same party throughout the trial. 2. Evidential burden. This is the duty to produce enough evidence on a particular issue. It may shift from one party to another as the trial progresses. Important features of burden of proof. It is a legal duty to prove facts. It generally lies on the person making the claim. It may shift during the trial after evidence is produced. It prevents decisions based on mere allegations. It ensures fairness and justice. Case study. Facts. Rahul filed a suit against Mohan claiming that Mohan had borrowed 5 lakhs rupees and had not returned the money. Rahul produced a signed loan agreement, bank transfer records, witness testimony. After Rahul proved the loan, Mohan claimed that he had already repaid the amount. Now Mohan had to produce repayment receipts or bank records. Decision. The burden initially lay on Rahul because he made the claim. After Rahul proved the loan, the burden shifted to Mohan to prove repayment. This case shows that the burden of proof can shift during the proceedings. Conclusion. The burden of proof is the legal responsibility to prove the facts asserted before the court. In every suit or proceeding, the burden initially lies on the person who would fail if no evidence were produced by either side. Although the initial burden usually remains on the party making the claim, the evidential burden may shift to the opposite party during the trial as evidence is presented.